Oh, sorry, I'm just getting some kind of message. Anyway, you have to sometimes just keep pushing courts and judges to move forward and challenge some of their notions about how courts should function. And I have been so excited by what we've seen happen over the last 5 years in this space. So if you feel anything that happens that I speak about today isn't something that can work in Virginia, I would challenge you to really try to make it happen, because I wouldn't have thought any of this work possible when I started practice 10 years ago. And we've seen a real culture change nationally in how we think about evictions. So just thank you for all the work that you do and for letting me share some of my work with you today. And I hope we can all support each other in trying to keep moving the needle here. All right, so I'm going to give you just a little background about my organization. I'm going to guess that none of you have heard of it before, although we are based in Williamsburg, so we're not terribly far from, I think you're in Richmond today, not terribly far from you. The National Center for State Courts was founded about 50 years ago, and the idea was that there needed to be a central hub to support state court systems. As you know, we have our federal courts and we have our state courts, and the federal courts, they're kind of a cohesive unit. Even though they're all across the country, they have a central entity that is supporting the judges, that's kind of setting a lot of standards for how they operate, that's collecting data, and they kind of function as a cohesive entity. That really hasn't been true for our state courts. Every state has its own court system that's structured differently and funded differently and operates differently, because every state is, of course, independent. But it seems that there was a need for some kind of cohesive support for states to allow them to learn from each other, to better share data, research, to kind of better try to operate in a way that worked for all stakeholders and communities. So our organization was created to serve as a central resource. So we do a lot of different things. We collect data from all of the courts so that we have national understanding of what happens in state courts rather than having 50 separate databases of court data. We do a lot of research, technical assistance, helping courts think through staffing, how they use technology, what they need in their physical spaces, cybersecurity, training for judges, and a lot of other different things. I'm on a team that's particularly focused on access to justice. So our lens is, how do we make sure that courts work for the large numbers of people who go to court every day and don't have a lawyer? Our courts were built to work for people with lawyers, and they were built by lawyers. And the reality is that's no longer the norm in our state courts. As you've probably all seen, huge numbers of people are having to go through this system without lawyers, and it does not work well. And so my team is very focused on thinking about the unique challenges for this population and how we need to push courts to better serve those needs. We also staff two bodies that I'm sure you've never heard of, the Conference of Chief Justices and the Conference of State Court Administrators. And those are the groups of the head judge in every state and the head court administrator in every state. And those bodies try to kind of set the national priorities for state courts and identify the emerging challenges and issues and set priorities for where they want to see state courts moving in the future. So that's just a little bit about our organization and the work that we do. And some of this will be obvious to you if you spent time in courts, but I do want to take a minute on this because I think people hear more about federal courts and think more about federal courts. And I do want to just take a minute to speak about why state courts are also incredibly important and often don't get enough attention. So every year in the US, 95% of all court cases happen in state courts. So while we hear so much about federal courts and federal judges, the reality is fewer than 5% of cases are actually brought in federal courts and heard by those judges. Now, those are often very important cases that have enormous implications, but 95% of the cases that are impacting kind of the everyday problems that everyday people have happen in state courts. And that includes issues related to housing, domestic violence, family matters, small claims matters, contract disputes, personal injury, auto accidents, all of these things that just are part of the legal problems that people navigate over the course of their lives are heard in state courts by state court judges. There is no constitutional right to counsel for civil matters. So while there is this right to a counsel for someone who is facing criminal charges, There's no equivalent of that on the civil side. So that means people who are navigating all of these problems I just described, housing, family, safety, often don't have a lawyer unless they have the money to pay for a lawyer and the ability to find a lawyer. So the reality is our courts are increasingly having to serve people who don't have lawyers, and they were not built to do that, or at least not built to do that very well. And each state court system is operated, funded, and structured very differently. And I'll touch on that a little bit more as I talk through some of the different programs we work with, and you'll see that they all look different, and that's often a reflection of how their court system is structured. And we'll talk at the end a little bit about some of the questions you need to make sure you understand about your courts in Virginia if you want to start advocating for similar changes. And there's some threshold issues that it's really helpful to understand about each court before you go in and try to work in that space. So state courts and evictions, that's why we're all here, right? Again, some of these numbers you've probably heard before. I know that all of you work in the eviction space, and so you're very familiar with these numbers, but I do always think it's important just to set the context for the magnitude of the problem we are all here trying to work through together. So every year in America, over 3.5 million eviction cases are filed. So that's 3.5 million families who are at risk of losing their home, having their kids pulled out of school, having just the humiliating experience of having their possessions kind of thrown on the yard in front of their house, the trauma of being displaced and going through this process. It's a staggering number of people every year who are struggling with housing instability. And I should also mention that's only the number of cases that are filed. We also know there are these informal evictions, illegal evictions, where landlords simply change locks or pressure a tenant to leave. Those aren't even captured in this data because they never even come through the court system. So that is only the tip of the iceberg for the real story of how many people are navigating housing instability every year. So every story starts differently. Every family ends up coming into eviction court for a different reason and through a different journey. But ultimately, all of these evictions, or at least the ones that are brought legally, are finalized in state courts. And eviction courts, as those of you who've read Evicted or heard about Evicted know, are often thought of for good reason as these places where justice isn't really served. They're defined by these high volumes. They have to churn through cases as quickly as possible. Lack of tenant engagement. A lot of courts will put 100 cases on the docket every hour, which is based on the assumption that 3/4 of those tenants won't even show up. And so you can just move through those cases very quickly. And of course, these systemic power imbalances. We know that tenants almost never have lawyers, and landlords almost always have lawyers. And that is baked into the fabric of housing courts, that there are these perpetual power imbalances. And of course, there's a racialized element to housing court as well. We know communities of color, people with disabilities, immigrant communities, and a lot of vulnerable populations are most at risk of eviction and have the most to lose through this process. So all of that is very bleak and dire, but now I want to switch and talk a little bit about some optimistic things and some space where we are starting to see change in this process and where we have to keep advocating for even more of this change to happen. During COVID-19, there was this moment where almost all evictions were halted across the country through the CDC moratoria, and then rental assistance in unprecedented amounts of money became available, and suddenly courts had this moment in time where they could do things differently. They could stop from this just churn, moving through cases as quickly as possible, and start to think differently when they didn't have to process cases because of the moratoria, and suddenly there were more resources than had ever been available before. There was this opening to move and talk to the courts and advocate for changes in the process. And we saw a lot of really wonderful things happen there. We saw courts inviting rental assistance programs to be on site at the courthouse, either physically or virtually. We saw courts being willing to stop cases from moving forward so that tenants could apply for rental assistance. We saw courts proactively even reaching out and telling community members about rental assistance and legal aid programs and doing a lot of proactive communications, which they typically haven't done. And all of this kind of came from this need to stem this fear of a tsunami of evictions, to stop these worst case predictions from coming true. But from our perspective at NCSC, once we saw courts being willing to take this step, we felt we have to keep pushing them in this direction. This can't just be a temporary pandemic response change in culture. The eviction crisis didn't begin with COVID, and it doesn't end with COVID. And we need to tell courts that this is how they should always handle these issues. They should always be open to creative solutions and proactive information and stakeholder engagement and different kinds of partnerships. And this is not just a temporary crisis. This is an ongoing crisis in our country. And these programs and changes and culture shifts should be a permanent part of the fabric of eviction court. And so that's kind of where the project that I lead comes in. The idea was we want to help courts take what they started during COVID and build on it rather than kind of unwinding it at the end of the acute emergency period. I do just want to take one more minute to just talk about some of the common reasons why courts haven't historically been engaged in this work, because these are some of the things that you may hear if you try to speak with your court partners. One of them is timing. There's often a sense that by the time a landlord-tenant dispute comes into court, it's simply too late to intervene. It's inevitable that this person will be evicted, and it's unfortunate, but the opportunity to resolve the issue has already gone by. And I'll talk a little bit about timing and why that doesn't have to be the case. Even though eviction court moves quickly, there is always an opportunity to intervene and offer some kind of assistance. Another common refrain that I have heard from working with courts is that they want to help, but they're concerned that this will undermine their neutrality, because courts need to be there to be these kind of decision makers when there's a dispute. They have these concerns that if they do things that are perceived as being tenant friendly, that will undermine their credibility to be neutral and impartial when they have to resolve disputes that come before them. So what we have kind of seen evolving over time is the understanding of what courts can and can't do. And I think the key thing to remember here is that courts need to be impartial, but that doesn't mean they have to be uninvolved and unengaged. And I think there's sometimes been a sense that if they even have a seat at the table, that violates their neutrality. And I think that we're seeing an evolving understanding in this, that courts can be part of the conversation. They can make it easier for other people to do work. They can engage with rental assistance providers and legal service providers and mediators and offer them space and resources and share information about those programs. And that in and of itself doesn't undermine their neutrality. What they are simply doing is helping increase the capacity of other entities to deliver services in their community. The court itself isn't delivering these services. It's just trying to be a connector and a capacity builder. And that is not inappropriate or unethical. And I think that more and more judicial leaders are starting to understand that and starting to think a little bit differently about where the line of what they can and cannot do is. And then the last thing that I think is often hard is that even courts that want to do better and change don't know how to get started. And before COVID, there were only a handful of eviction diversion and prevention programs that were running through courts across the country. And there weren't a lot of places to look to get help or to see examples. And that's shifted. There are now dozens and dozens of eviction diversion programs across the country. There are organizations like mine that specialize in helping courts design and implement programs like this. And there's a lot more national support and a lot more national examples and best practices, which I do think make it easier for courts. A lot of courts, they don't want to be the first to do something, but they're okay with being the third or fourth to do something once they've seen someone else try it. And now we have enough of an understanding of how these programs can function without the entire system collapsing, that I think it makes it much easier to start these conversations and share examples of what other peer courts are doing across the country. So in terms of the different kinds of solutions, I kind of tend to think about them as programs, policies, and rules as the three kind of buckets of ways that you can work with courts. You can help courts establish different programs that, and I'll talk much more about this in a minute, that give people alternative ways to resolve disputes. You can help courts think about policies that simply make court more user-friendly and accessible. And then you can help courts think about rules. And I'll talk more about this at the end. But a lot of people think about statutory change as the way to change the process, and statutory change can be a really impactful tool. It's also very hard. It's hard to go to a state legislature and advocate for change. It's slow and it's difficult. Court rules, on the other hand, can be changed in a much quicker and more nimble and more localized way. So I often talk to people about trying to use the court rule process as a mechanism for change, rather than trying to engage in kind of statutory change, which requires advocacy work that's not always feasible or acceptable for different entities to engage in. So with that, I'm going to talk for a while about programs, because that's what I do, and then I'll touch at the end a little bit on how you can also think about potential to change court policies and court rules. So, all right, to bring it back, I lead our eviction diversion initiative at the National Center. The project's about 2 years old, and what we do is support state and local courts in designing, launching, and implementing eviction diversion programs. And that always leads to the next question of, well, what does that mean? What is an eviction diversion program? And I know that eviction diversion is a phrase that gets used in a lot of different ways. My lens is working with courts. So this is our definition that we use when we think about eviction diversion through the lens of a court system. We define these programs as any program that uses the formal court process to give landlords and tenants time, information, and resources to resolve housing disputes in a less harmful way. This definition is a little bit vague because every court is different. It has different governing laws, it has different procedures, different policies, different structures, and different partners. So we don't want to be too prescriptive and tell courts there's only one way to do this when our country is large and diverse, and our programs need to be a diverse reflection of that. But we also have a few kind of core elements to these programs that we think are critical to them working effectively, and that's the time, information, and resources, which I'll talk about in a little more detail. And again, because these are court-based programs, in the way we think about it is mapping out the formal process for an eviction and trying to integrate these programs on top of that process. I know there are a number of eviction diversion programs that are really trying to catch people before they are court involved, and that is also wonderful. That's just simply not kind of our lens because of our role of working with courts. So before I kind of jump into giving you some examples of programs, this is kind of my top level message on all of this, is just that we need to think differently about courts, and we need to challenge our assumptions about what courts should look like, right? This is, if you close your mind and think of a court as probably something like this. It's a room, there's a judge in a black robe who sits at the front, there's a lot of people sitting on benches at the back. It's a very formal process, it's intimidating, it's hierarchical, and it's often imbalanced. And this is how we've kind of accepted that eviction court should be for a pretty long time, and how it typically is across the country. And I just challenge everyone here to think about a different way to do eviction court. And these pictures on the right here, and you'll hear more about both of these programs in a minute, this is what eviction court looks like in two of the courts that we work with. At the top, that's the court we work with in Fort Wayne, Indiana. That's not a judge. That is a holistic resolution specialist. When people come to court, they don't go to a courtroom and they don't see a judge. They sit down with Tanya in her office, and they talk about why they're in court, what the problem is, and then they talk through all of the different ways they can resolve it. And only if they reject all of those alternatives do they then get scheduled for a second date in front of a judge. So the idea there is the judge is the last resort, not the first resort. And we've kind of flipped on our head this idea of what happens in court. And the picture on the bottom right is from Lansing, Michigan. That's the eviction resolution office. They've tried to create a trauma-informed space that uses color and art and creative furniture choices to create a neutral, inviting, warm space for people to come in and, again, talk about their issues and what has brought them to court and look for resolutions. And again, there is no judge who shows up at this court proceeding. The judge is the last resort, not the first resort. So court doesn't have to look the way it may look in your mind or the way it looks on TV. There's nothing in statutes or the Constitution that says court has to be a guy in a black robe who sits at the front of the room while everyone else sits at the back shaking and waiting for their turn. Court can look how we as a society decide we want it to look. All right, so these are the 22 courts that I'm currently working with through this program. These are not the only eviction diversion programs in the country. There are many, many more. These just happen to be the 22 that are a part of our network of courts and that are kind of working with us in a strategic way to implement these programs. We're also running an evaluation, so we're collecting data from all of these courts, which we'll be sharing in a report later this year that will hopefully show that these programs are effective and a really good investment of resources. As you can see, we're all across the country from Alaska down to Texas. We've got big states and little states, big cities and rural communities, and we're really trying to show that these programs can work anywhere. It doesn't require a certain demographic composition or population size, but really we can take these principles of eviction diversion and resolution and adapt them to work in any community or any court setting. And now I'm going to speak about some concrete examples of what these programs look like. And some of this, as I said, I'm a lawyer, and I'm sorry, some of this I'm sure will be boring and too technical and in the weeds. I've really tried to not do that, but I suspect I have missed the mark. But if there's anything here that you're interested in learning more about, please, I know we have time at the end for questions, or feel free to put things in the chat. I can try to talk on them too. But I'm going to go through and talk about timing, information, and resources as the three key elements of a court-based diversion program. And I want to just share examples of what that looks like in practice. So timing, we know eviction courts move fast. In most states, there's a time frame that's set by statute, either state or local law, that says the case has to move at this speed. And eviction cases tend to be among the fastest cases that move for our court systems. While some cases may languish for months or years, evictions are usually resolved in a matter of days or weeks. And that is often a time frame that is not flexible, but set by law. So we have to think about how these diversion programs work within the reality of whatever your statutory constraints are. So here's what a typical eviction process looks like in most states. There's a little bit of variation here based on state law, but it's usually some version of this. The first thing that happens is the landlord serves some kind of notice on the tenant, and that's a piece of paper that says you violated your lease, either you didn't pay the rent, or you violated some other provision of the lease, or I just don't want to renew your lease. You have a certain number of days to fix the problem or move out. And if you don't do that, I'm going to file a case against you. Some places that notice period is as short as 3 days, and some it's as long as 60 days, but it's usually some version of that. If the tenant doesn't pay or fix the problem or move out after that notice period expires, then the landlord can file a case against them in court. After they do that, the sheriff will go out and serve the complaint and the summons, and the parties will come to court for their initial court date. And then there will be some sort of trial. In many places, that trial happens on the first court date or maybe the second court date. It usually doesn't go much more than 2 court dates. And at the end of that, the judge will rule, more often than not, in favor of the landlord. With our diversion programs, what we want to do is try to disrupt this process. So at different stages along this map, we want to build an off-ramp. And so, while sometimes eviction feels like a conveyor belt that's just moving people very quickly forward to eviction, we want to break that conveyor belt and offer alternatives at different stages. And we have programs that are using different moments in time to try to catch people and give them this off-ramp. We have programs that are trying to get people pre-filing. So when the landlord initially goes to court and tries to file, have you thought about not paying your fees to the court and not having to hire a lawyer, but instead trying to resolve this on your own outside of court? We have programs that are trying to catch people once the case is filed, but before they come into court. So as soon as that filing hits the court, people start trying to call the landlords and tenants and say, I see you filed a case. Do you want to resolve this before you come into court? And then we also have in-court programs where they wait until the landlord and tenant are there at the courthouse and try to bring the resources on site at the court and give people an opportunity to engage with different service providers before they go to the judge. And then the idea with all of these is the same. We just want to give people every opportunity to resolve this without going to trial. Nobody wins when we go to trial. And so to the extent possible, we want to look for other options to resolve this. And a lot of our programs will even have multiple entry points. They may invite people to participate before filing, but realistically, it's really hard to find people before a case is filed because we don't know who they are. Once a case is filed, we've got names, we've got an address, we've got contact information, and we have this kind of finite universe of people. So it's much easier to start calling them and doing outreach since we know who we're trying to reach. So a lot of places will try to do pre-filing, but knowing that we're going to miss people, they will also want some kind of post-filing or in-court entry point as well. So what does this look like? This is where I'm going to get a little technical, if you'll bear with me, and just walk through a few programs. And I'm going to start with pre-filing and kind of go into in-court. So pre-filing is great. If we can get people early, I think it's the best opportunity. That the landlord-tenant dispute hasn't kind of gone as far, so they might be more willing to work with each other. Once the case is filed, oftentimes, emotions are high, there's money invested in it, and it becomes harder to try to resolve it. But if you can get people early before the dispute has really festered, it can be much easier to try to get them to talk to each other and to agree to work something out. So we really do love pre-filing when we can make it work. So in our court in Alaska, what they have done is they've been able to get a rule adopted that requires when a landlord gives someone that pre-filing eviction notice, they also have to give them this information sheet you see on the right that lets the tenant know about the eviction diversion program. So the tenant at that point, before the case has been filed, can reach out and start talking to the eviction diversion program staff and learning about their opportunities to mediate, about rental assistance, about legal services, and just start getting basic information about the process and what's going to happen. It's really nice and simple because by this one by implementing this one rule change, they've been able to make sure that every tenant gets information about the diversion program as early as possible in the process. Now, one question that we always get is, but what's in it for the landlords? Why would they want to do this? Because this is a voluntary program. The landlords aren't mandated to participate in it. And some of them might think, I'd rather just go to court. I know what's going to happen. I'll get the eviction. It'll be quick. It'll be easy. I don't know about this pre-filing program. So the court there has been able to create a few different incentives to get landlords to engage with this program earlier. One, if the landlord tries to resolve the case early and they're unsuccessful and they do have to file a case, their filing fees are waived. So there's a little bit of a financial incentive for them to try to resolve it early because they won't have to pay to use the court system if they do have to use it downstream. The second is that there are a few pots of money that are only available to landlords who are trying to resolve cases through pre-filing diversion. In Alaska, most of their ERAP money is gone. They've got a few small pots of rental assistance money that aren't available to the general public, but some of that money is available to people who get referred in through the pre-filing diversion program. So this is the only way that a lot of landlords would be able to access rental assistance. They also have a small landlord mitigation fund. So a landlord who agrees to keep a tenant who's deemed as a high-risk tenant can access this mitigation fund if the tenant ends up damaging the property or defaulting on rent. The landlord has a little bit of financial security through that. And then the last thing the landlords wanted was to know that if they settle the case and the tenant violates the settlement, they'll be able to go into court and get the eviction judgment. And so the court has agreed that whatever is resolved outside of court through pre-filing will be an enforceable legal judgment if they have to go into court. And that's been really helpful in getting landlords to consider participating in a program that otherwise might not have been, that might have been a very hard sell for them. So that's just one example of a pre-filing program, and that program is fully remote. It's statewide in Alaska, which is obviously a geographically enormous place, and so everything is remote. All of the services are provided remotely, remote mediation. The program staff are based in Anchorage, but work across the state. Another example of a pre-filing program is in Colorado, where they have a mandatory pre-filing program. But the catch here is it's not mandatory for all landlords. The legislature passed a bill last year that requires landlords offer mediation to tenants who receive certain means-tested public benefits. If they receive SSI or they receive TANF or some state public benefits, the landlord has to give them an option to mediate their case before they can file an eviction. And the reasoning there was that those tenants, because they have a fixed income, are more likely to be able to come up with a payment plan and to kind of pay back what they owe. And they wanted to give them that opportunity to negotiate it. They don't have rental assistance. That's not a reasonable, that's not going to be a factor in resolving these cases now. But that was tenants who have this steady source of income might be able to work out a payment plan, or there are some kind of short-term bridge loans that they might be able to access. And so they wanted to mandate that for this class of tenants. And if a landlord does not offer the mediation and just files the case, the tenant has a defense to the eviction. So that's kind of how they force the landlords to do this. We don't see a lot of mandatory pre-filing programs. There were some during COVID. Most of them have sunset since the COVID emergency period ended. But this is an interesting example of one state that's trying to do mandatory pre-filing diversion, but in a very limited capacity. And so I just share this with you because they're the only state I'm aware of that's doing this. And I think there's a lot of interest in whether we can just carve out certain kinds of cases and really steer them to pre-filing diversion while leaving everything else as a voluntary program. So those are both pre-filing. So the idea with both Colorado and Alaska is that you're trying to encourage people to resolve cases outside of the court system. These next two examples are all post-filing. So this is after the landlord has filed that case. You know, once there is a pending case in court, how can we try to work with them to resolve it without going to the judge and going to trial? So this is an example from Las Vegas. And Las Vegas, I think, is right now the epicenter of the eviction crisis. They had 60,000 eviction cases filed last year in Las Vegas, which is a massive, massive number. And they're on track probably to have a similar number this year. So it's huge. And all of the government partners and community partners there are really committed to finding some way to reduce that number of filings. It's just too high. So in Las Vegas, they decided that they wanted to create a post-filing diversion program. So once the tenant or the landlord has initiated the court process, they want to try to divert some cases. But they wanted it to be an opt-out program where the court staff would screen cases and essentially enroll them in a diversion program unless the tenant opts out of it, which I thought was an interesting model because we often put the burden on tenants to find out about something, to find out about rental assistance, to find out about legal aid, to find out about mediation, and to kind of ask to participate. And in Las Vegas, they said, we want to take that burden off the tenant and we're just going to put them in diversion right away unless they don't want to be in it. So what they did is they amended their tenant answer. Nevada is a state that requires tenants to file an answer with the court before they can participate in their case. I know that's not the same in every state. I'm not sure if that's the case in Virginia, but every tenant has to file an answer, but they added a number of screening questions in this tenant answer. So now in addition to just kind of, what are your defenses to the eviction and those other kind of standard questions, they also ask these things about their income and their rental history and their goals and why they fell behind on rent. And based on the answers here, they have a rubric that identifies who they think is a good candidate for diversion. And they'll schedule them for an appointment with a social worker. And the social worker is a court employee. When they come to the courthouse, they meet with a social worker. They can apply for rental assistance. They can apply for cash assistance. They'll do a public benefits screening to make sure they're getting all the state and federal benefits they're entitled to. They might be able to apply for some subsidized housing programs, and they're also connected to legal aid and mediation. And so the goal here is people, similar to Colorado, people who might be able to stay housed if they can just get some help, making sure they have access to all the financial resources they should have access to. We'll catch them, get them a social worker, get them a case manager, and really focus on helping them resolve this issue with their landlord before they go and deal with a judge. So that's a really creative model. This one is a bit of a lift from the court because the staff at the courthouse have to screen all of these, but they have just found in Vegas that they are in such a crisis mode that they can't handle 60,000 evictions a year, and they needed to get creative. And their thought was, it's cheaper for us to hire some social workers than to hire more judges, which is what we'll need to actually process 60,000 cases a year. So the hope is by sending some people to a social worker instead, they'll reduce the burden on kind of judicial staff to have to handle these cases. So I'm really interested to see kind of what the data ends up showing here about how this has worked and what outcomes they're seeing. All right, another kind of post-filing opt-in program is in DC. So in DC and then also Vancouver, Washington here, they're both kind of similar models where after a case is filed, then they start trying to reach the tenant and landlord before their court date and encourage them to use diversion. So it's not like Las Vegas where the tenant's going to get automatically enrolled in diversion and set for an appointment. The tenant does have to take a step here, but they want to make it easy for the tenant. So in DC, they've done a massive outreach campaign. They did bus ads and metro ads and social media ad buys and community events, and have really tried to get the word out there in community that there's this new program. And if a case is filed against them, they don't have to just kind of wait and go to court. They can kind of try to reach out and engage with the program ahead of time. One thing that's been really helpful there is they adopted a new court rule that requires every landlord to share the tenant's phone number and email when they file an eviction case. And so the court staff now can call the tenants and email the tenants, and that makes it easier for them to do outreach. Similarly, in Vancouver, Washington, they adopted a court rule that every tenant is going to get information about the diversion program in their court papers, and they encourage them to reach out ahead of time, and they can access legal aid and mediation, and also referrals to a lot of different kind of health providers and community providers. In Vancouver, they also have a program for small landlords, where small landlords can get conflict coaching assistance and kind of legal information and support, understanding the eviction process as well. So I think that's really interesting how they've tried to serve both populations, understanding there are some small landlords who are really struggling to navigate the system and are struggling financially right now as well. So they've got two elements to their program there. And then the last kind of program is the in-court program. So with everything I've talked about till now, they're all trying to catch people before they show up at court. These two programs here, for a variety of reasons, just decided that wasn't going to work. And their goal was going to be getting people to come to court and then catching them once they showed up in the courthouse. Now, that raises some questions around timing, because once someone's at court, you're pretty far downstream, right? You have less opportunity to resolve the case, and they're already there. The judge is on the bench. They've got the scheduled court date, and so you're pretty late in the process. So both Michigan and Cook County were able to pass court rules that allowed them to, once people come to court, to pause or slow down the case so that people would still have a chance to engage with the diversion program. In Michigan, if a rental assistance application is pending, by court order, it stops the case for 14 days. And then the Michigan Supreme Court also entered another court order that requires no trials on the first court date. So the first court date is really focused on giving people information about resources, and no trial can happen until the second court date. In Cook County, every case used to be set for trial immediately on the first court date, but that wasn't a requirement by statute. And so the judge was able to enter a court rule that, again, said no trials on the first court date. Judges have to agree to give people at least 14 days to try to resolve their cases through other mechanisms before they can go to trial. So in both of those, they're not trying to get people upstream, but they are trying to just slow down the court process so that there is an opportunity to engage with a program before they go to trial. Those in-court diversion programs can be either in person or remote. On the left is a picture from Indianapolis, the program we work with there, which is a fully in-person program. And they've just invited all of these different service providers to come on site at the courthouse. So when you come into court, you see these lovely ladies who greet you. They've got a big sign behind them, so you can't miss the message that you can get help at this court. There's rental assistance, there's legal aid. You don't have to worry. The judge isn't going to call your case until after you've talked to everyone. You can go and talk to all of these organizations right here, right now. In Cook County, which is where I live in Illinois, we have a fully remote program because we're huge. We have 6 courthouses, and we wanted to make sure everyone in each of the 6 courthouses could have access to the same resources, and that requires delivering them virtually so that all of the legal aid and rental assistance providers can meet with people from across the county. So all the courts on Zoom, and through the magic of breakout rooms, people can get moved in and out of the courtroom to meet with a lawyer, to meet with a rental assistance provider and start an application, to meet with a mediator, or potentially all 3 of those things. And it works quite well. Sometimes it's a little stressful. There's literally 50 breakout rooms open in every court hearing, but they use a Slack channel on the back end for the court staff and all the service providers to be in communication about who's going where and when, and it works quite well. So that's just, again, to say that not every program is going to look the same way. They're all a reflection of what's possible and what's needed in the community. But, our job at NCSE is to help everyone just think through the options and figure out a program model that can work for them. So that was all just kind of on this idea of timing, that with evictions, thinking about when you try to intervene and when you try to integrate these different services is really important because of the speed with which cases move. And it may be before court, it may be during court. It doesn't really matter. There's no right or wrong way. You just have to be very thoughtful about that timing intervention. So the second piece is resources. I think I've talked a lot about you've got to give people time for the diversion program to work, to access these service providers. And now I want to elaborate a little bit on what that means, right? The heart of an eviction diversion program is the resources. You need a place to divert people to. Even the most motivated landlord and tenant who don't want to go to trial, they don't want to deal with a judge, they want to resolve this, they're going to need some help to resolve this issue. And that kind of comes in the form of community resources. And that's kind of really crucial here. So we try to, with all of the courts we work with, to really push them to think holistically, right? People come into court with an immediate legal need. They've got a court paper that says you're behind on your rent, or you had an unauthorized occupant in your unit, and that's why your landlord's trying to evict you. And that's what they show up in court with, but that's usually not the only issue. And so we want to really push courts to not just put a Band-Aid on the immediate problem, but to dig a little deeper, right? So there's this immediate legal need that presents in court, but there's often these interconnected legal needs. Maybe someone fell behind on rent because of a wage garnishment issue, or maybe someone fell behind on rent because they need to appeal a public benefits decision, and they have these kind of interconnected legal needs. And that rent issue is just kind of the most recent legal need, but not the only one. So we really want to encourage courts to look at what has brought someone, what are the circumstances that led to someone being in court today, and what's happening kind of below the surface. And then beyond the legal needs, there are all these other compounding needs as well, right? Once someone's experiencing housing instability, they may also be struggling to access these other basic needs: healthcare, childcare, food security, kind of school services, and all of these other things. And courts have often had blinders where they've only looked at the legal issue that someone came into court with. And this is something where we're really seeing an evolving understanding of how courts need to do a better job of serving the whole person and really embracing that they are part of a community, and there are a lot of other resources in this community. And while courts have this one specific function to resolve the legal need, if they are catching people who are in crisis and need other support, they can be a point of connection to help people address these other interconnected legal and non-legal needs. And that's been, I think, a really wonderful development that we're seeing in more and more courts, is kind of looking globally at what someone needs and not just at what they need at that moment in time. So with all of the courts that we work with, we have them kind of think about doing a service mapping exercise to think about what are the resources in their community that can help the landlord and tenant resolve the immediate problem, but then what are the services in their community that can help the landlord and tenant on a path to long-term sustainability, so they're not just going to come back into eviction court in a few months or the next year, right? We don't want to do Band-Aids. We want to fix these problems in a sustainable way. So in terms of resolving the immediate problem, because there is this case that brought someone into court, and we do need to deal with that, right? You can't get into these longer-term sustainability questions until you've gotten rid of this case that's kind of lingering right there. So in terms of resolving the case, it's usually a combination of legal aid or pro bono services. Figure out who are the legal service providers in your community, pro bono organizations, law school clinics, who else is out there and can work with landlords and tenants to help them identify defenses or achieve settlement or whatever else may help them kind of get through this case. Mediation is often a common partner. A lot of places either have a community mediation center or a court-based mediation program. We have found that landlord-tenant cases are really good fits for mediation, especially cases where the landlord and tenant are both unrepresented, or where there are kind of personal dynamics at play in addition to the legal issues. So we see a lot of success with having mediators help people have a productive conversation and work towards kind of a shared resolution. And then financial assistance programs. A lot of eviction cases are truly a function of money. Sometimes there's not anything else going on. The landlord and tenant get along fine. It's just that the tenant can't afford the apartment. So we really want to help tenants understand, could you afford the apartment if you've got some kind of one-time cash infusion, or we're able to clean up your public benefits? Would you be able to stay in this apartment going forward? And how can we figure that out and get you on that trajectory? Or is this an apartment that you cannot afford and there's no kind of long-term path to you staying here? And then how can we help you relocate in the least harmful way and figure out a place that's more long-term sustainable for you financially? And then in terms of preventing the future crisis, that's where we want to engage this other web of social service providers. Housing, counseling, and education is really crucial. A lot of our courts are trying to help do more education around how to forge stronger landlord-tenant relationships, how to understand your rights and responsibilities as a landlord and tenant. Are there housing navigation services that might help people who need to relocate? And what are all of the different opportunities to support landlords and tenants in that way? Financial counseling and empowerment is a great one. A lot of our courts are trying to engage financial counselors to come in so that to help tenants with money management and budgeting issues, to help them make sure that their housing situations are going to be long-term financially viable for them. And then wraparound supportive services. Again, we know people often need help accessing all these different services and trying to engage local school districts to make sure that kids' education won't be disrupted if the parents have to move. Making sure that people know how to access mental health and healthcare services, public benefits, and all of these other services that are really crucial to long-term sustainability. So here are just a few examples from our cohort. Everyone is working with legal aid and mediation and rental assistance, such as it is. That's just kind of a given. But these are some of the other partnerships that we're seeing. For example, in Indianapolis, they have been able to partner with a storage facility. So if a tenant needs to move, but they need a place to put their things, maybe they're going to go and stay with a friend or family member for a while, but they don't have a storage facility, they've been able to just call some local storage companies and get them to donate storage space so the tenant can move out and know that their things will be secure until they're able to find new housing down the road. We have courts that are putting together apartment listings on a weekly basis and compiling those and sending them out to tenants to try to make it a little easier in knowing that if they have to move, here's another resource for them. We have courts that are doing on-site public benefits screening. I mentioned Alaska has a risk mitigation fund for landlords. A lot of places are partnering with their local housing authorities and local government to help make it easier for people to do rapid rehousing or kind of clean up issues with vouchers or other kind of public housing issues. We have courts that are doing Rent Smart classes or financial counseling classes for landlords and tenants. Sometimes that'll be paired with a mediator, so they agree to work out their issue, but the tenant's going to go to financial counseling and the landlord's going to go to a good landlord class, and so everyone kind of has homework to do afterwards. So a lot of different creative partnerships here. And then we have one in Colorado that I do want to mention also. They have I mentioned this earlier, they've got their pre-filing program, but they also decided to start a post-filing program because they just saw that no matter what they did, some group of tenants were going to get evicted and they just did not have any way to stop those evictions from happening. And they didn't like this idea of those tenants kind of leaving court and having nothing and nowhere to go. So they started a post-eviction support group where they have hired a dedicated court staff person whose job is just to help tenants with emergency transition planning after an eviction is entered against them, making sure their kids are getting transportation to school, helping them get placements in shelter, helping make sure that they have a place to send their pet if they're going to go into a shelter that doesn't take pets, and just thinking through all of these other things. And it's a very difficult work to do, and it's extremely important that they do it, because until we get to a point where no one is getting evicted and we're a ways away from that, it's really great to see court thinking, you know what, we don't want to just evict people and then have that be the last time we see them. We want to have this longer term engagement to make sure they're going to be okay even after this eviction judgment is entered. And I think that's really a unique thing about that program. And I'd like to see other sheriff's offices or courts thinking more about what do we do to support people during this emergency transition phase as well. We can't just kind of let people leave court and just say that our engagement has ended. We want to be a part of whatever comes next as well. All right, so just a few things here. This is something I always say with courts, and this is probably not as relevant to you, but courts are often not good partners. They kind of, will often just give people information that's out of date or not relevant to them. And so we talk a lot with courts about if you're going to engage with community partners, you want to be a good partner. That means you need to understand your partners, who they are and what they do, and you need to communicate with them. And that's all new for courts. They don't have a deep history of engaging with community partners and service providers. And so there's a learning curve for them. But we always want to make sure courts understand the intake process, because I do sometimes see judges say, call legal aid, they'll represent you. And what happens is oftentimes tenants call legal aid and legal aid can't represent them because they have intake criteria and they have capacity limits. And so we don't want courts or judges or court staff to give people false hope. We want to make sure that when they refer people, they can give them the information they need. You're going to apply for services. It might take you a few days to hear back, and kind of set those expectations for tenants so that the tenants have a better experience and they know what's going to happen when they leave court. And also so the service providers don't end up in this position of having angry community members who are promised something is going to happen only to find out it's not going to happen. We really want courts to engage have regular feedback loops to make sure that their information is current and accurate, and that there are opportunities for them to dialogue with their service providers if things aren't going well or if there are changes. We always want to prepare litigants, and this is true of anything. People who are going to court, they just want to know what's going to happen. What's going to happen next? What do I need to do? Where do I need to go? And anything courts can do to prepare people for that. Where do you need to go? Who do you need to talk to? And then can you reinforce that message by putting it in writing? Can go a long way to helping to kind of take away some of the anxiety and stress that comes with going through court. And then we encourage courts to share information, data, and space. When courts can have data sharing partnerships with service providers, rental assistants, legal aid, whoever it may be, it can allow a more effective delivery of services. It can allow for kind of more coordinated referrals and just a better experience for folks. And there's a lot of examples across the country of courts that are doing a great job of this. But we do really encourage courts to not just think that you've had one meeting with a service provider and that's it, but these are ongoing partnerships that have to be nurtured and maintained and often need to kind of iterate over time. And so that's something where courts are constantly learning and trying to do better. All right, and then the third piece of an eviction diversion program that I wanted to touch on is information. And I think this is something that I know this group is very well aware of because you've all done such great work in Virginia to push out information about rental assistance. But we know that people often don't come to court or people don't know about these programs. You can design the best program in the world with all of the partners and do everything right, and it won't work if no one shows up and actually engages with it. And courts historically aren't great communicators. They communicate in legal jargon and kind of very intimidating language. You know, the sheriffs are out there in uniform delivering papers, and it's often not the best way to reach people or to have your message be heard. So we try to really push courts to think differently about how do you currently communicate with people and how can you do it better. And that's little things that I'm sure you all know. Write in plain language. Stop using legal jargon. Stop talking about unlawful detainer and entry and just say eviction, right? Use words that people understand what they mean. User-centered design. You know, for some reason, I think courts are obsessed with everything fitting on one page, and they'll just shrink the font and shrink the margins, you know, till it's 6-point font and right up to the edge of the page so that everything can be on one page. There's no reason things need to be on one page. Write things in a way that people can read them, understand the information, and act on the information, right? There are a lot of principles of user design, white space, trying to prioritize the most important information, and there's a lot of work that can be done to take the existing court papers and simply make them better at doing what they need to do, which is give people usable, actionable information. And then how can we also supplement that? You know, these court forms go out and they're all about come to eviction court, you're being evicted, you've been sued. How can we also soften that message by adding information about resources? So every program we work with has created a supplemental flyer that goes out with the eviction court and summons that also says, I know this thing has happened and this is scary, but we want you to know there are resources here to help. And so there's always a secondary message that goes out as well. So there's not just this negative message about court, but also this optimistic message about how people can get help. And then of course, we want courts to move beyond what they have to do by statute. And all they have to do by statute is send out the summons and complaint. But, you know, think about text messaging and email reminders. We know those are really effective in a lot of industries, and we're seeing more courts that are experimenting with those e-reminders. Community outreach. If court is not always a trusted messenger in the community, who is? And how can you engage with those community groups that can kind of amplify this message that go to court, you might be able to get help. The court process is different now, the court experience is different now, and there might be other partners who are better positioned to have that message heard, especially in communities that have historical reasons to mistrust the justice system. And then social media. Courts aren't super great on social media, but more and more we're seeing them set up social media accounts, trying to make websites that are more usable and just meet people where they're at. Create an Instagram page, right? You know, we know that's how people are getting information now. And so we're really trying to push courts to not just do what they've always done or what they're required by statute to do, but to understand that they have an obligation to communicate with their community members in a way that will allow their messages to be heard. So just a few examples here. This is a before and after from a court summons in Ohio. On the left, you know, it's just kind of, you look at it, it's a little overwhelming. The information about going to court is kind of buried halfway down. On the right, you know, we've redesigned it for them to try to, in the box at the top, just give the key message. You've got to go to court on this day and this time. And then also to put in all this information about get help in the middle to encourage people to reach out ahead of time. So, you know, it's still a legal notice that has to have all that statutory and required information, but there's a way to make it just a little easier for people's eyes when they look at it to see what they need to see, rather than just kind of glossing over it. These are just some supplemental things that our courts are using. On the left is a resource sheet that gets mailed out in Milwaukee with the summons and complaint. It's required to go out on yellow paper too. So when people get that thick stack of court papers, there's one, I think it's goldenrod actually, one goldenrod sheet of paper that people's eyes are drawn to. They can pull it out and it'll tell them there are resources, reach out now. And that kind of helps make it a little more distinctive. On the right's a postcard. So in Suffolk, New York, they decided they wanted to send out a communication that was separate from what the sheriff delivers. So they also do a postcard mailer that is usually the first communication someone gets before they're even served. They'll get this notice that there's a case in court, that we're here to help you, reach out. And then of course, text messaging, a number of our courts are experimenting with that. And then community outreach here, and I won't spend too much on this because I know that this has been such a big part of the work around rental assistance, but again, bus ads, you know, library sessions, community outreach, and this is all new for courts. Courts are used to waiting for people to show up at court, and this is a bit of a culture shift, this idea that people from court might actually go out into community, but it's really something that we need to see courts do more of to build that trust and build those relationships. And of course, landlord engagement, because courts are neutral and impartial, they have to make sure they're engaging both landlords and tenants. On the left is a picture of a landlord information session in Tennessee. I think that one of our courts did. The right's a flyer from the courts diversion program that's kind of geared towards landlords to let them know that they can help even before a case is filed, and give them some of the reasons why they might want to do that. All right, and then the last thing I'll talk about is some court improvements. So I should say in my job, I travel around the country and I visit courts, and I come back and I take pictures of everything I see. All of my coworkers make fun of me that someday in retirement, I'm going to make a series of coffee table books about court signs, but I love visiting courts. I love seeing some of the great things that are happening in courts, and also some of the opportunities for improvement in courts, because in a lot of courts, there's some real low-hanging fruit. So I just want to share here some of the things that we encourage all the courts we work with to do, and these are some things that you might be able to work with your local courts on, because a lot of these are, again, pretty simple low-hanging fruit, just really doing those small things that make court a little bit more accessible and more welcoming. All right. So to start with, I just want to provide a few stats here on non-appearance rates. And a lot of this is all kind of geared towards just getting people to show up at court and understanding why they don't show up at court. So in the criminal space, you know, about 30% of defendants don't go to court. In the debt space, you know, about 40% of defendants don't go to court, but eviction is the highest of any area of law. 50% of tenants across the country do not go to court, and I've seen jurisdictions where it's as high as 75%. And the real sad thing here is that a lot of courts just accept that as a given, that, you know what, 75% of people aren't going to show up. Well, that's their choice. What are we going to do about it? And that is not an acceptable status quo. We cannot just settle for this idea that we're going to evict people without even giving them an opportunity to engage in the process. And so I think it's crucial to understand why people don't come to court and to try to address some of those systemic barriers that keep people from coming to court. So we do a survey at my organization every year. Here's the one from a couple of years ago about what are some of the barriers that people experience when they come to court. So childcare is huge. 22% of people say childcare is a reason they don't come to court. And for people under 40, it's even higher. Time off work or school is huge. People don't want to miss a paycheck. They don't want to fall behind on school to go to court, especially if they don't think anything good will happen at court. Distance to travel is huge. Court is not always conveniently located. It may not be on a public transportation route. It may not have free parking. And so that transportation is hard. We know that about 40% of people in eviction court have physical or mental disabilities. And so those accessibility issues are huge barriers too. And then this is from 2021 when, you know, COVID was probably more of a concern, but it's still very much a reality that COVID still circulates along with other infectious diseases, and that for some people, especially who are immunocompromised, that idea of putting themselves in this kind of setting is risky and scary, and maybe a factor in not going to court. On the right here, we also have some stats, and these are from a couple of years ago, about people's comfort level using video conferencing services. And these numbers are actually higher. I should have updated this. I think we're up over 70% now. So you can see at this time, like 80% of people were comfortable or a little comfortable with going to virtual court, and that number has gone up by now. And I mentioned this because a lot of places did remote courts during COVID and then stopped doing it at the end of COVID. And we have really encouraged courts to not just stop doing this thing that we know works and that can make a big difference in helping make court more accessible. So here's just kind of a few strategies for improving appearance rates. And I'm going to show you some pictures in a minute of, some of these things. Reducing travel time, though, is a huge one. Remote court proceedings can be enormously helpful. In the courts we know that are still offering remote court proceedings, they have higher appearance rates almost across the board than other courts. People are often calling in from work or from the car on their way to school, and giving people that opportunity can allow them to participate in court without having to choose between a paycheck or coming to court. So we really encourage courts to not just stop doing remote now that they know how to do it. And then reducing costs of travel time. I work with the court in Tulsa, and when they send out the eviction summons, there's a QR code on it, and if you scan it, you can get 2 free bus passes from the Tulsa Transit Authority, so people don't have to pay for the bus to go to and from court. It's only $5. It's not a huge amount of money, but for people who are in eviction court, that $5 can be an enormous amount of money. And so just reducing that one little barrier can be very, very helpful for making sure that people don't have to do these cost-benefit calculations about, is it worth it to go to court? Flexible scheduling is one. We've seen a lot of courts that just put 100 cases in an hour, and people might sit there in court for 2 or 3 hours. We've really encouraged courts to think about scheduling differently so that people do not have to be stuck in court for so long. Can you schedule cases in 30-minute blocks or hour-long blocks rather than just, telling everyone to show up at 9 and then spending 3 or 4 hours going through all the cases? Why don't you do them in kind of smaller chunks of time? We have a couple of courts that got Calendly subscriptions and are even experimenting with letting tenants schedule their own meetings at court. So there's a lot that can happen there to make it easier for people to go to court at a time that works for them, or to have to invest less time in going to court. Better notices we touched on already, that people may just simply not understand that they need to go to court, or they may not understand why they need to go to court if the notices don't do a good job of conveying those messages. So we need to look at every piece of paper that goes out to tenants and make sure we're reinforcing this message over and over again, that you have a court date, and if you don't come to court, you will lose your case. But if you do come to court, you might get help, and just really amplifying that message. And then creating user-centered courts. Can we create spaces that are more welcoming, more trauma-informed, more family-friendly, that people want to be in, rather than spaces that feel hostile and uninviting and scary, which is often kind of how courts are designed to be intimidating. So here are just some pictures from courts that I visited over the last year, and how they are trying to, in ways big and small, really kind of change this idea. Courts don't have to be these towering pillars that are designed to be imposing, but can also be places that welcome community members. All right, so, and some of these are just really small things, but welcoming signs. And I think you've probably seen these signs earlier already. One of these is from a court in, I think, Fort Wayne, Indiana. And when you show up at court, they just have yard signs in the front that say free help inside, which is just a really nice message to see when you show up at court and you're nervous and you're scared and you don't know what to expect. To see this multilingual sign that says you will get help inside is really a different message than what courts are usually conveying. And of course, on the left is the sign that I showed earlier from our court in Indianapolis. Normally, when you walk into court, the first thing you see is a security guard and a metal detector, and they're yelling at you, take off your belt, everything through the metal detector, you can't do that, don't do this, you can't bring your coffee in, and all of that. And they do have to do that in Indianapolis. But then once you get through security, the second thing you see is this very welcoming message that there's legal assistance and there's rental assistance here. And that's a much more positive message for people to experience when they walk into a courthouse than kind of the typical message of don't do this, don't do that, you'll get in trouble, and all of those other things that are pretty standard. Art, I'm a big fan of art in the courthouse. It's kind of it can be helpful to kind of bring down stress levels. It can be therapeutic for people to have that. It gives them things to look at. There's kind of a lot of research around, art is just being a really helpful thing. And this can be expensive, but it can also be very cheap. So on the right is a picture from Alaska. And in Alaska, 1% of their judicial budget is allocated for art. So every year they can spend 1% of the entire judicial budget on art, and it's all from local or indigenous artists. And it's really beautiful. And I've visited a few courthouses in Alaska, and it's just always really inspiring to see the art and to kind of learn the stories of the indigenous communities in Alaska and how they're expressed through art. And so I love that. But it's also not realistic to think that every court system is going to allocate 1% of their budget to art and be able to kind of bring in real, artists to kind of do all of this work in the court. But there are ways to do it on the cheap. So on the left is a picture from Lawrence, Kansas, where I was visiting a couple of weeks ago. And they have asked court-involved children to draw pictures, and they're posted on the walls around the courthouse. And then they also have kind of words and images from court-involved children that play on PowerPoints. And that's obviously a much cheaper way to do it than to hire professional artists and commission work, is to just use who's already there. They also have a gallery in the courthouse where local artists can display and sell their work at the courthouse. And it makes it a much more pleasant experience to walk down these long hallways to the courtroom to kind of see color and art and children's words. It really kind of changes the experience, the physical experience of navigating that space. So I'm a big fan of looking for ways to add color and art into courthouses and courtrooms. Family-friendly spaces is a huge one. So many people in eviction court have kids. I think upwards of 60 or 70% of people who are sued for eviction have minor kids in the home. And sometimes those kids are going to have to come to court. And sometimes people don't go to court because they don't know what to do with their kids, or they think their kids won't be welcome in court. This is a more expensive thing, but some courts now offer on-site childcare, which is a really wonderful resource to offer. But again, that's expensive. The much cheaper workaround is to just have a little corner of the courthouse or the courtroom or the self-help center where you put some books and some toys and some coloring books to just convey the message that we understand you have children and you have a family and they may need to come with you to court, and that's okay. It's okay to bring your kid here. That's a really different message than often what's conveyed by courts, which may seem almost hostile, this idea of people having children and having kind of the need to go with having children. We also see more and more courts that are putting these lactation pods in the courthouse so that nursing parents have a place where they can kind of go and have privacy. Also, as someone who was a practicing lawyer when I had my first two kids, I would have loved that as well too. So it's really nice to see more courts that are trying to create these spaces, which are incredibly helpful for people who need them, and also just really change this message that, court is trying to meet people where they're at and meet their needs. Self-help resources are hugely important. I suspect those of you who spent time in court have probably seen a little bit of this. I think Santa mentioned at the beginning, the self-help center up in Fairfax County that's quite new. We see a lot of courts that do have self-help centers or law libraries that do self-help, which is great. If your court doesn't have one of those, though, that doesn't mean there aren't other ways to create and deploy these self-help materials. And it's really important to also make them available at different junctures in the court process. So on the left, this is a picture from a clerk's office in the court, I think in Michigan, where they've just got all the self-help forms there and they've got them clearly labeled and listed. So it's easy for people to go in. They've got an eviction, the clerk can just say pick form 3 and pick form 7. They've tried to make it simple. On the right is a resource table in a courtroom in Alaska. Every courtroom has these kind of color-coded sheets that they just lay out at the beginning of the docket. So they don't have a self-help center. They just kind of turn every courtroom into a self-help center and kind of give them resources for that court type, which I think is just a nice way to do it. And I think they're very well designed and colorful and easy to read. And then on the bottom right is a sheet from a program we work with in Wichita. They've just found that people leave court and they have this court order, and they don't really know what this court order means. It's too legalistic, it's too technical, and they don't really understand what they need to do with it. And so they had tried to get some changes made to the actual language on the court order. That was difficult. So instead they created a supplemental sheet. So people get this next step sheet, and it just kind of goes through the high level. You got this court order, it's got a lot of legal jargon on it, but here's what it means. You've got a trial on this date. And then it's also got these check boxes at the bottom. So based on what kind of referral someone gets, they'll have that information. You can apply for rental assistance. You can try to talk to someone about getting, health resources, and just trying to package whatever happened in court into a much more actionable, easy to read, easy to follow resources. So I think self-help is really important, and it's pretty low-hanging fruit. These are easy to do. My organization has a lot of resources and templates to kind of help courts and court partners think about self-help and how they can create it and use it and deploy it in different ways. And it can be expensive and robust if you have a fancy self-help center, but it also really can be as little as a sheet of paper that's just trying to say the same thing in a slightly better way. So there's really a lot of ways to scale this up and down to better help people just move through the process and understand what's happening to them and what's going to happen next. Multilingual signage, these are pictures from a couple of courts we work with that are just trying to make sure that people can get information in the languages they need. We have a very diverse country with a lot of language needs. It's really helpful to understand the community you work in, what are the biggest language needs there, and are you able to share information and resources to people in the language that they need to receive those in. You know, most courts do have interpreters, but not every court is equally good at letting people know interpreters are available. So again, it's no good to have an interpreter if someone doesn't know how to ask for an interpreter or that they can ask for an interpreter. To do the court papers that go out, let people know you have the right to an interpreter. Here's how you can request one. If not, that's really good language to advocate for including or to try to push out that message through other ways so that people know language access should never be a barrier, or disability access, a barrier to coming into the court system. Plants and natural lights. You know, these are courts that I love because they have a lot of light. Courtrooms don't typically have windows in them. Sometimes that's for security reasons. Sometimes that's because they're old buildings. I'm a big fan of natural light. Now, if you don't have windows in your court, that's a hard one to fix. But plants can also be really lovely. The picture on the left is the eviction courtroom in Wichita, Kansas. And I just think that the plants are just a really nice palate cleanser in what otherwise is a very stressful space. And that's a very, very easy and cheap thing to do. Just, again, add some art, add some plants, and try to make the spaces in your courthouse a little bit more welcoming and humane and accessible. All right, and then I think this is my last one, and then I'll just talk for a few very quick minutes about how to start advocating for some of these changes, creating welcoming environments. So on the left here, this is a PowerPoint slide deck that plays in the courthouse in Harris County, Texas. That's Houston. And they just got a lot of legal information and resource information that plays on these slides actually in the courtroom and in the hallways as well. So when you're in court waiting to be called, they're just playing through these slides with a lot of information. You know, they let people know that we've got an eviction diversion program. And then there's a picture too. This is Loretta. Look for Loretta with the purple hair and she can help you, which I think is a really nice message to kind of reinforce. The middle one is just phone chargers. I saw at a court once, and it's, again, it's just acknowledging people's needs are many and varied, and maybe they need to charge their phone while they're waiting for court. Phones are a really crucial part of, you know, how people engage with the world now, and what a nice thing for a court to just anticipate that need and meet it. And then the right, this is a very simple thing, but I counted 18 courts last year in 15 states, and I only saw one court of those 18 that used the words please and thank you in the signs that they communicated to the public. Every court has a sign when you walk into the courtroom, no hats, no cell phones, you know, no crop tops, whatever. They all have a long list of things you can't do, which creates kind of, you know, the sense that whatever you do is wrong. And they never say why, and they never say please, they never say thank you. So I just like that this one has a big please, don't do these things. And I do think it softens the message and just makes it a little bit more of a hostile environment, because we really are trying to de-escalate the hostility in the court process. And sometimes that can be as simple as a please and a thank you, which are not typically how courts engage with community members. Okay, I know I'm running a little low on time here, so I'll just skip through this one very quickly, but these are court systems that have pledges of fairness, where they post in their courthouses what their goals are and their values and their missions, which I do think is nice. Courts don't often think of themselves as parts of community, but they are, and kind of just reinforcing that message that we're here to listen to you, to treat you with respect, is really a shift from kind of these unapproachable courts and judges that we often kind of think of in our minds. All right, so now you're thinking, well, that's great. Now I want to put a plant in my courthouse. Who do I talk to about getting that plant in the courthouse? And the answer is, I don't know. It's going to be different in every courthouse. And this kind of goes back to the very beginning of every state court structured differently. Some of them, all the decision-making is centralized in, you know, Richmond or whatever their Richmond is. And some of it is all very localized with individual presiding judges. But these are the folks who are typically involved in making changes to the eviction process or to the court experience. And you'll have to do a little bit of investigation to find out who this might be in your local court. I'm very happy to talk to folks, you know, offline after this, you know, to help kind of think through how to do some of that investigation. But judicial officers, whether it's a judge or a justice of the peace or municipal judge or whoever hears evictions in your cases, that's certainly one. Those are folks who often have control over their courtroom. So if you're just thinking about things like, I'd like to put some flyers in the courtroom, or I wonder if we could put a plant in the courtroom, that's where you start. And some judges don't like change, and some judges are pretty radical. I was in a courtroom recently with a judge who doesn't wear a robe because he said, I'm part of the community. Why would I separate myself from the community members by wearing a robe? I'm just going to wear regular clothes because I'm here just hearing the kinds of disputes that impact people every day, and I don't want to separate myself from that. So there's a real range of how people think about their role as judges. But that they have a lot of control over what happens in their physical space of their courtroom. So that's one. Bar associations and bar foundations are often kind of involved in court reform efforts, especially ones that increase access to legal services. So thinking about how courts engage with legal aid and pro bono and other practitioners or landlords bars. That kind of advocacy often happens through bar associations and bar foundations. Sheriffs I mentioned because sheriffs are often there at the very beginning of a case. They're serving the court papers and they're there at the end doing the lockouts. And so sheriffs sometimes can be really great partners in, can they take out a flyer at the beginning, when they're serving court papers and make sure people get information. And then at the end, when people are being displaced, can they identify people who are going to need some kind of social service support and help make those connections? There are a lot of roles where that kind of sheriff law enforcement might be a valuable connection because of how they see people at the extremes of the case. Clerks and court administrators, people often don't really know who those people are. But clerks and court administrators have a lot of power and control. They often decide what forms are deployed in a courthouse, what signs go up in a courthouse, how cases are scheduled in a courthouse, what kind of information gets mailed out, text messaging reminders, websites, things like that are often controlled by the clerk and the court administrator. So it's really helpful to understand who those individuals are in your community and to think about different ways that you can engage them. Access to justice commissions, I believe you have one in Virginia, and they often do a lot of this kind of work at a statewide level. So they're kind of great partners to just understand what's already underway and how you can maybe help implementing those changes at a local level. And then, of course, engaging with housing advocates, housing providers, all of those other folks who are stakeholders who have, a lot invested in these changes and these processes too. And I'll say with kind of all of this, one thing is that everyone's very busy. So even people who want to make change, it's really hard and overwhelming to think about how to do it. So when you can come in with really specific asks and offer to be a partner in making these changes, it can go a long way, right? A clerk may say, I'd love to have better self-help information, but I don't have the time to develop it myself. So if you can kind of make all of this as simple as possible, well, we can create this resource, create this flyer, we'll work on it for you. It can be much better to do it that way. And one thing that I often find when engaging with kind of court administrators and judges is they like things that can be done by agreement of both housing advocates and housing providers. So, oftentimes the landlord community and the landlords bar don't have the same interests as the tenant advocates and kind of tenant representatives. But sometimes there are areas of agreement where everyone can see there are too many cases, it's putting a strain on the system. We need to think differently and kind of trying to find those overlapping areas of agreement and presenting things that can be done, in partnership can be a much easier sell to courts. But again, I'd be happy to speak with folks kind of offline about how to begin these conversations and how to just even start thinking about who these individuals might be in your community. All right, and then to just kind of wrap up very quickly here, I think I mentioned this at the very beginning again, but I tend to think about three mechanisms for change. One is these formal programs, like what I described, the eviction diversion programs. I know you're doing court navigation and things like that. Those are really, really great. But the other ways to make change, especially some of these smaller changes around the court experience and the court building, are through policies and rules. And just to give some examples of what's done by policy, remote versus hybrid versus in-person hearings, that's generally something that at the individual court level, the court administrators and the judges decide. And that can be done by a policy. That doesn't generally require any kind of statutory change. And so that's one thing to consider is what are the court policies right now around remote hearings? And is there Is that something that's being used effectively to increase access to court proceedings, or is there room for improvement there? Scheduling and timing of dockets, that's done locally by court policy. Do people show up at court at 9 o'clock and then wait 6 hours for their court to be heard? Perhaps we can talk to the court about scheduling things differently. Or perhaps maybe if there are a lot of pro se landlords in your community, perhaps the court would consider having a separate docket just for pro se landlord cases, knowing that they have different needs and there are different opportunities for case resolution. We see a lot of courts that have tried to kind of do a docket just for pro se cases or a docket just for public housing cases to try to group cases that may have special needs and special services available. Data sharing tends to happen by court policy too. So if you're finding that your courts aren't sharing data that you need to do outreach or to kind of understand what's happening at court, those are conversations to have with court administrators. And then of course, court rules. And as I said, you can do a lot by court rule. It doesn't require any kind of statutory or legislative change. So it's a really nice way to do it. We see courts that have adopted rules that are requiring landlords to attach rent ledgers, leases, eviction notices with their court pleadings, so that the tenant has more visibility into what the allegations are against them. And it's easier for legal aid and rental assistance service providers to kind of understand what's going on when that information is disclosed up front. So there's been a lot of movement around the country to really try to front load that information so that there's a lot more that gets included with the eviction summons and complaint, and people don't show up at court with no real understanding of what's going on. Resource information, all of this can be done by court rule, requiring that landlords send out information about legal aid and rental assistance with the eviction court papers. That's just an easy court rule, and we've seen courts everywhere in the country making those changes. As long as you make the flyer for them, they seem pretty happy to require it be included. And that's been a great culture shift from, oh no, we couldn't tell people about legal aid, that would violate our neutrality, to, oh no, please, we want to tell people about legal aid, help us do it better. And then the last one here is restricting access to court records. I know there's been a lot of discussion nationally about sealing eviction records and about the harm of having that eviction record in someone's history, even if the case doesn't result in an eviction judgment. Just that filing can be very, very harmful. There's a lot of legislative advocacy to seal more eviction records, but we also see a lot of courts that are in states that don't authorize sealing of eviction records to finding ways around that through court rules. So I've seen courts say, well, we can't seal eviction records, but we don't have to put them up on our online docket. So if there's an eviction case that's settled, we'll keep it publicly available, but you have to come to court and physically pull it. We're not going to put it on the online docket, which effectively seals the record because most people are trying to look for information online now and aren't going to go and pull physical records. So that's a great workaround. Another one we've seen is, well, we can't seal the record, but what we can do is not name the parties in the eviction judgment. So I've seen some judges who will just enter cases against unknown occupants. So the record is publicly available, but their name isn't on it. So again, it's not sealed, but it has the same effect of protecting someone. So I just mentioned all of this, and there's so much more that can be done by court rule, just to stress that you don't have to go to a great lengths to kind of lobby for statutory change. That may not be within the priority of your organizations to do that anyway. There's a lot that can happen locally through court rule that can really alleviate the burden of eviction on tenants, make the process work better for everyone, and really help change kind of the culture and communications around eviction. And that can be done through local policies and rules with just a little bit of time and effort to engage stakeholders and kind of advocate for these changes with the decision makers in your community. So I think I'm right at time there. So I'll just kind of wrap up with, our goals for these programs, I think, are probably pretty similar to a lot of your goals. We want to reduce evictions when possible. When evictions are going to happen, we want to allow tenants to move with dignity, with time, so that they can have a fresh start without that judgment hanging over them. We need to rebuild trust in our courts. We know that public trust and confidence in our justice system is eroding rapidly, and programs like this that are community driven and community informed can really help change that culture and narrative and bring people back into the court system. And we need to increase service provider capacity. We don't have billions of dollars in rental assistance coming again anytime soon. And so we need to all work together to be more effective at getting whatever resources and dollars we have deployed in the most efficient and effective and impactful way. And that requires courts being a part of these conversations and coordinating closely with all of the partners in their community. All right. So with that, here's my information. And I also know that we've got some time for questions after this. So I will wrap up. But thanks for letting me share this with you. And I'd love to hear your questions, reactions, ideas, and anything you think you might want to take home to your courts.
Thank you so much, Samira. That was fantastic. You're a wealth of information, and there's so much complementary work, I think, happening between your grantees and the grantees in this room. So just thank you. I'm so grateful for you. Our agenda gives us about a 15-minute break right now. And I'm sure you probably could use a break, Samira, from your computer. So we will reconvene at 11:45. For the people in the room, our lunches are over there and Gabby is organizing them for you. But Samira, if you just want to like turn off your camera and mute yourself or something, and then rejoin us for lunch at 11:45.
All right. I will see you soon. Thank you.
Thank you. Yeah.
I'm trying to be good. Yeah.
I know you had Jim, thank you for 12.
Oh, yeah.
Oh, yeah. I felt bad, I felt worse. They really have 100 pounds of fast every day.
Oh, no.
Should be like 35.
Oh, and I just want to remind everyone that you will get copies of the presentations from today, so don't feel like you have to write everything down.
Or maybe they don't. Oh, I thought you was getting ready to say.
No, I know he's talking about. No.
For mediation coordinator, or court navigator couldn't come. I said, what's the? No. Yolanda. Yolanda could make it. Gotcha. Yeah.
My granddad. So if there's a.
You can only steal from. You can only steal. Yeah.
It's funny because in there. Oh, I said stuff like that. No, you can't.
So it was, you know, you're younger, it's like, oh, you don't have a 6 foot now.
Right.
It's like,
No, it's
like
not.
that.
What was going on?
Things fast and speak.
No.
Yeah, that's expected. It's the game. I'm like,
Yeah.
you still got to point now, right now. Yeah.
Information.
Yeah. But. What?
There's a. Yeah. They already got the 40 number.
It's like, yeah, and then. Yeah.
I did, I just couldn't. I didn't know.
Just because of these positions. You don't get the package on the gas, it's about like, no, it's not, you know, that's a one thing, but that's the, yeah, right, exactly. So, because he had a friend. And they do really get us and that, yeah, so working the process is like very, it's very important. They don't really have like families. You kid not get all. Yeah, I like. The way I'm like stating, they just burn my skin. I was like, I guess I'm taking that. Yeah, have that time right there. Come back next year. Oh, no. They want you to, how do you come? That Paul is saying. All this. And now. I said, in that way. Yeah, I mean, even for it's just some of our time. Yeah. It brings us. Yes. Slowly but surely, but, and then the person listen to it. And put your size up. I thought your stuff. You're also know who's influencing your choices. Like, I didn't know pretty much, the judge was going to go to things, because he's what. Stuff happened. Especially when the chief judge was like, Denise said, sure, used to put all of the flyer with the court notices.
It is, because I know that was one of the things that
Different.
probably lost it and has funneled down so they could do it. I mean, you know, I'm sitting there asking.
Because they used to do it, they used to have the hotline and then the heart. If you have a family, bring this notice to hearts.
Because, you know, we have some deputies on the legal team. I'm gonna ask if they still, because I have.
Because I know that fortunately, it's like, no, it look like we're supporting something, I'm like, no, it won't. We call our one regional number, it's not like both.
But just like, it's not taking away from your personality, like giving these. Yeah,
We did it, though.
No.
No, I know, fortunately, we consider putting the pressure. So this isn't the same, but it's fine. They used to every year, then all of a sudden they just stopped.
whatever.
No. Thank you.
Yeah.
Keep it out too.
Probably gotta get over. She said.
And the road, he comes up, he's. Even they. We've had so many rules that.
Yeah, okay.
Pick up and notice different. Healthy services, you know, like. The planner had a different set of problems, but it could at least be like, even, hey, they put you under on paper, we write. And then what they would do is cancel that one, and refile the that. But it gives me that like 4 or 5 days to try to do something. So. I'm like.
When they don't.
I grew up in Philly.
Part of all is negotiation. Exactly. Is trying to get the law towards.
Even from the West Coast. So there's times when it is.
Maybe like a program, I'm just like.
Yeah, yeah.
But.
Small company, let's say, like, yes. Why didn't I see more things?
No.
I haven't been out, it's not fine.
Yeah. She looks funny. Yeah, she's like. Oh, okay.
Engagement, that.
So that comes down to TV interview. Here's a real next president. No, it's just a very character that was changed for the engagement. Yeah, I can check that one. Oh, sorry.
Oh my gosh.
Yeah.
Weird.
Yeah.
You know what I think it's actually for, if you look at Brown residential.
Oh.
It's made right for her, it's a, yeah.
Yeah. They're, my friend was there, but I didn't ever. Nice, yeah. That's awesome. And where they live. So.
She got that one stage. She went into it, the question, and she thought, well, I didn't have to look at everything like her dad. For her. Yes.
Yeah.
And she said, well, I'll do it myself. This is the hair bubble. It's better. So. And you might go, and you can just. You're not. And it is, it's like. Yeah. Yeah.
Right, I actually, yeah, I was thinking about it, I do remember having, I had one of the basic here. Whenever you came out.
Yeah.
Just not. Yeah. I like the. Yeah.
I really like where it's at.
I know, I think you.
I feel like I feel like I learned it all over the year.
So much stuff.
You guys are
It's right there.
The functionary was actually in charge. And then.
Yeah.
That really like, oh, wow, here. That was.
I used to be a program staff.
Yep.
Yeah, very.
I know. It's okay. I'm used to owls. They never really cooperate. It's probably just because it's closest to me.
You know, that? No.
Did you move the